Good morning, Professor Clapham. I would like to thank you on behalf of the Cambridge Journal of Law, Politics and Art for joining us this morning to discuss the valuable insights of your work in international law, human rights, and humanitarian law. Your career spans decades with experience as advisor to the Special Representative of the UN Secretary General in Iraq, Amnesty International representative, the UN, member of UN Commission on Human Rights in South Sudan, and more. You were also the first director of the Geneva Academy of International Humanitarian Law and Human Rights from 2006 to 2014. And you are a well-published professor of international law at the Graduate Institute in Geneva with your most recent book titled War, released in 2021. I'd like to start by asking how your diverse experiences, both as practitioner and academic scholar and author, have been informing your thoughts and your work, and maybe briefly what your focus has been recently as well.
Well, thank you very much for having me. I suppose it's difficult to be working in this area and not be thinking about the war in Ukraine. Obviously, there are multiple legal developments related to that conflict. I don't pretend to be on top of all of them, but if you ask me what I'm thinking about, it's a lot of the issues connected to that conflict, partly because they haven't come up before in recent times. For example, the issues of neutrality and funding and supplying arms to either side of the conflict. The questions of naval warfare, interference with ships, search of ships, that hasn't come up before, at least not in recent times. And so those are some of the issues. Well, I know we're going to talk about war crimes later. And then the second thing that I'm thinking about at the moment, if you're asking, is the prosecution in Stockholm, Sweden, for complicity in war crimes of the chief executive, former chairman of the board of the oil company Lundin, for their activity in Sudan, as it then was, in the sector where Lundin was doing oil exploration. That also is a groundbreaking prosecution, and I'm trying to follow it as best I can. It only started a few days ago, but it's going to run for 2 years. So I'm trying to get my head around that as well.
Right, that's very, very interesting work that you do, and there's so many avenues to consider with regards to these very complex conflicts. And delving right into it, we wanted to know, beyond international mechanisms, do you think Ukraine is currently equipped to prosecute such war crimes? And what are the main challenges Ukraine would face in prosecuting these war crimes?
Right. So I think, Ukraine has a criminal code, and it arguably covers the relevant war crimes. The main difficulty, I think, is not necessarily in the legislation or even the existence of courts, but in actually capturing people who could be prosecuted. Obviously, they have captured prisoners of war, but some of those have had to be exchanged for Ukrainian prisoners on the Russian side. So even historically, looking at some of the prosecutions that there have been, even after conviction, if I've understood correctly, those prisoners have been swapped for people held by the Russians on the other side. So trying to prosecute war crimes in the middle of an armed conflict, you come up against these competing interests, which is to bring your own people home. The actual definition of the crimes is a complicated area, but what I would say to you at this point is that this is unusual in some ways as an armed conflict, because you have the application not only of all 4 Geneva Conventions, but also Additional Protocol 1, because both Ukraine and Russia are parties to Additional Protocol 1. And Additional Protocol 1 includes a list of war crimes relevant to this conflict related to attacks on civilians or disproportionate attacks involving civilian casualties. And so it wouldn't be that difficult to prosecute such war crimes because they are defined in a treaty ratified by both sides. So a lot of the media talk about how the fact that neither Russia nor Ukraine have ratified the Rome Statute, but actually the Rome Statute is for prosecuting people in the International Criminal Court, and it's based on these crimes which exist in treaty law for some time now. So I think it's certainly possible. And the fact that these crimes are grave breaches under the Geneva Conventions means not only that they could be prosecuted in Ukraine or Russia, but that they could also be prosecuted in any state in the world, because every state has ratified the Geneva Conventions. So, and many of those states will have national law that allows them to prosecute a grave breach of the Geneva Conventions, even states that are not parties to the ICC. So, for example, since January this year, the United States has adjusted its law. It could prosecute anybody accused of grave breaches. The United Kingdom has something called the Geneva Conventions Act, which gives jurisdiction to the British courts to prosecute those who are accused of grave breaches of the Geneva Conventions. So that would be the aspect that I would stress, that the universal jurisdiction, if you like, because every state in the world is a party to these treaties, stems from the Geneva Conventions and not from something called international criminal law or even the ICC.
Right. And do you think, in your opinion, would Ukraine need to amend any of their laws to align more with ICL standards in order to prosecute these crimes and establish accountability? And what would need to be amended? Or is it, as you said, that it's not the Ukrainian national law that would pose an issue? It's more the
No, I
convention.
think there is room for amendments in the Ukrainian law. I think one of the issues is relates to command responsibility or superior responsibility, that the Article 28 in the ICC statute, I think it is. And so if you wanted to prosecute command or superior responsibility in Ukraine, I've had a discussion with some people. It may have changed, but my impression was that it would be quite tricky. But of course, many of the war crimes, and if they capture the people who've committed those war crimes, you wouldn't need to use superior responsibility. But that's one gap which has been identified. So if you captured a commander who had not participated as the primary perpetrator, but had failed to discipline or punish his or her own soldiers, then you might want to or have to use command responsibility. And that indeed, I think, could be complicated under Ukrainian law. But there may be other ways under Ukrainian law that I don't understand as to how you could indeed prosecute somebody for command responsibility. In terms of the other crimes, I think there are efforts to try to bring it more into line with some of the long list of crimes in the ICC statute. But I think for the very basic crimes of sort of murder and sexual violence, you would be able to use the war crimes concepts from the Geneva Conventions, which are sort of indirectly incorporated into Ukrainian law because it talks about criminal responsibility for violating humanitarian law treaties, which Ukraine is a party to, and that would obviously cover the Geneva Conventions.
In your recent book titled War, you explore the evolution of the term and how the different notions of war with a small w or war with a big W in armed conflicts may produce different implications and consequences. And indeed, Russia prefers the term special operation, and individuals may be tried for treason by merely referring to it as a war. So this gives us an idea of that, it does have that grave implication. And in your opinion, which category would Russia-Ukraine fall under, and what laws may apply in that case?
Right. So it's true that the Russian authorities have avoided using the word war to describe the operation. Although, ironically, obviously I'm all reading this all in translation, but my impression from some of the reports I've read is that they do talk about a war with NATO. And so there's a sort of distinction between how they see the others. And maybe it's partly related to the idea that they are sort of reincorporating Ukraine back, and so they don't see it as a war with another state. But to be frank, I don't think that's why the Russian authorities have avoided the word war. I think the word war suggests an all or nothing combat. And I think to suggest to the people that we are at war or we are going to war suggests that young people will be conscripted and that the whole economy will be mobilized. And that, I think, might be a frightening concept. And so a special military operation implies something smaller. Now, whether or not one could use the word war with a capital W, as I've used it in the book, I've used it to mean a formal declaration of war under the old law of war, where some conflicts were not considered war with a capital W because there had been no declaration of war. As far as I know, there's no declaration of war by Russia or Ukraine, or any sense that they are at war with a capital W. And so, to answer your question, I would consider this war with a small w, or simply an armed conflict. The difference it makes, I won't go into a long explanation, but it might make a difference, for example, under some human rights treaties which allow for the death penalty in time of war. There, I think you need a formal war and not just an armed conflict. So it could be significant. The other area is in naval warfare, where some people might consider that the law of prize, that means the law that entitles you to seize enemy ships outside neutral waters, that really requires a declaration of war. I don't want to get into the details. So there could be reasons why the states might choose not to make a declaration of war, or why in the future they might make one. But for me at the moment, it's not a war with a capital W.
And you have also written about just war theory in the case of Ukraine, and that it may be time to consider holding lower rank and file soldiers responsible for fighting those conflicts in the same way we hold higher ranking military leaders responsible. Can you explain this concept for our readers and elaborate on the shortcomings of our current concepts of the just war and responsibility?
Yes, thank you. So in traditional just war theory, philosophers feel that there should be something called the symmetry of soldiers, or the symmetry of combatants, that whether you're fighting on the just side or the unjust side, you should be treated the same, unless, of course, you commit a war crime. But the mere fact of fighting, even for the aggressor side, should not lead to punishment. And that is defended strongly by traditional just war theorists, because they feel that, well, I'm not sure exactly what their key argument is, but one of the arguments which recurs is that, well, if they were going to be punished for simply fighting, there would be no incentive to abide by the laws of war. So if when you're captured, you're going to go to prison for simply being on the other side, then what's to stop you from killing civilians or raping, because you're going to be punished anyway? I personally don't think that's a good argument. I think, you would obviously be punished more if you've committed war crimes. And I don't think people commit war crimes thinking about whether or not they're going to be punished. I think you need a much more complex analysis to try to dissuade people from doing that. So I don't think it works. But then the sort of secondary set of arguments is, well, if you do that, you're going to have an impossible task, because if there is an army of 100,000 people and they're all aggressors, then you can't prosecute everybody. And so you make a mockery of the rule of law, and you undermine the whole concept of law, because people are violating the law every day and you're not punishing them. Again, I don't think that really holds up in the sense that clearly you're not going to punish everybody. You've got to capture people, and you're not going to waste time punishing people who had no real role in the aggression. You're going to punish those, yes, there may be foot soldiers, but those who have engaged sort of knowingly in furthering the aggression, not people who were peeling potatoes, not really understanding what was going on, sitting at the back of the lines. So my suggestion was that we need to start to think about punishing those on the aggressor side and not consider that they have some special immunity which comes from philosophy. Now, in law, it gets more complicated in that the additional protocol does say that you have the right to directly participate in hostilities. But again, in Nuremberg, people were prosecuted on the military side for assisting the aggression. And I think it would be possible, without violating the rule that says you have the right to directly participate in hostilities, to start to think about a crime of aiding and assisting the crime of aggression. And this brings me back to my answer to your very first question, that if we start to think about prosecuting those who assist the aggression, then that starts to open up the possibility of prosecuting businesses and business leaders for supplying the equipment which allows a state to engage in an aggression. If we start from the idea that you can only prosecute the head of state for aggression and the top general, but you can't prosecute all the people who have helped in that aggression, I think you let a lot of people off the hook, all those who are making money out of the war and fueling the war on the aggressor side. And I think they should start to think that maybe they too can be considered as liable under international law. So those are my sort of reasons why I think it makes sense to start to think about those who are helping the aggressor and not say, oh, but traditionally you can't look at either one side as worse than the other because that's how it's always been. But that's how it's always been goes back to the time when disputes were settled in a duel-like mentality. We have a dispute, so we'll go to war, and then God will reward the winner, and then that's how disputes are resolved. But today, if you have a dispute, you're supposed to go to the UN or the International Court of Justice, not fight it out on the battlefield. And if you've chosen to start a war, I don't see why not just the leader, but all of those who knowingly go along with it can't be punished too. Now, my students tell me, and other people tell me, oh, but a lot of people, will be coerced into going to war and they won't really understand it, or it'll be a life and death. They'll be shot if they don't go to war. To which my response would be, well, we could deal with those cases one by one when it comes to the prosecution. If somebody genuinely feared for their life and had to go to war and ended up being on the aggressor side, but didn't commit war crimes, maybe they don't get punished in the same way as somebody who organized all of the troops or somebody who built all the bombs and sold them, making a profit out of the war to the aggressor side. So it's a bit of a taboo subject in just war theory. The mainstream, even those who take a more revisionist approach, don't really want to touch the idea that soldiers can't be prosecuted merely for participating in a war on the aggressor side. But I'm saying maybe the time has come to change that approach.
I agree, definitely. I think a lot of how we deal with war, as you said, goes back to very archaic ideas, and it's time to modernize that and, address disputes the way we address all kinds of other disputes. And I completely agree that, with those subject to propaganda and who are forced to be drafted against their will, that, through evidence that would come out. And, it also depends because some some soldiers would be way more aggressive than other soldiers. And I think that really gives an idea of the kinds of individuals involved in the conflict. And following in from that, what practical limitations may arise from broadening the scope of accountability. As you said, if we don't stop at soldiers, then we might bring in corporates as well, which is also very, very important. And so, yeah, what practical limitations may arise from this, and what avenues may be available to address these, do you think?
I'm not sure there are practical limitations. I mean, I'm told, oh, but that means prosecuting 100,000 people. But that's not really how war crimes law works. Not all the war criminals are prosecuted in any conflict. A few people are, a tiny minority of those who have committed the crimes. And I think it could be the same for prosecuting the crime of aggression. It's not that you're going to take everybody in the prisoner of war camp and then prosecute them for the crime of aggression. But I think what we need to challenge is the idea that nobody can be prosecuted except a few leaders. And is it practical to prosecute corporations and their directors? I think absolutely yes. In some ways, it's easier because, first of all, the corporation, it can't move around in the same way that people can. They can sort of disappear, they can change their names. But if you are a major corporation and you're supplying parts, knowing that they're going to be used in a war of aggression, you can't just disappear. You're listed on the stock exchange, you have assets, you have reputation. So I think it's a question of changing one's focus rather than that it is impracticable. It's practically perhaps more difficult because corporations are well funded almost by definition, and they will be able to pay for very good lawyers to delay prosecutions, to challenge jurisdiction, and so on. But we'll see what happens now with this Swedish case. It's going to run for 2 years. I think it's the longest case in Swedish history. And it will be watched, I think, very carefully by corporate directors around the world. And whether or not either the corporation has to pay a fine because they have already had some money frozen by the Swedish prosecutors, or the directors are punished, I think it will give pause for thought to other directors. And I think maybe it's worth reminding that such a prosecution can happen for war crimes, but in the future, it might also be for aiding and abetting the crime of aggression. The rule that says that you can only prosecute the leaders is a rule for prosecuting aggression at the ICC. It's not necessarily a rule, in my view, for prosecuting aggression in national courts. So I think a lot of states have rules that say the crime of aggression can be prosecuted and here's the punishment. And those same states have rules on aiding and assisting an international crime. So what I'm suggesting is that it could give some companies and their directors, more importantly, pause for thought.
Yeah, I think it's about time that corporates are held responsible and used as an example that, you just because you're a corporate doesn't mean that there's no individuals behind it who are making these decisions, who are playing that part in these armed conflicts. And it's not just these military leaders that are directly involved. In 2018, the ICC gained jurisdiction over cases under the crime of aggression charge, with the important exception that it cannot exercise its jurisdiction over an actor from a non-signatory state. And as a result, the international community has turned to the idea of a special tribunal for aggression to hold Russia accountable for its invasion. And how optimistic are you in this path? And does this focus on a tribunal weaken the role of the ICC as an institution?
I don't think it weakens the ICC as an institution. I mean, the ICC has plenty to do already. And if one were to give it, the extra task of creating a dossier and prosecuting the crime of aggression at this point, it clearly has to diminish how much attention it can give to war crimes. On the other hand, having said that, politically speaking, it does look strange that the ICC can't prosecute a Russian leader for the crime of aggression, even if Ukraine were to be a party to the statute. That seems odd, and it seems, in the sort of press and the media, as the ICC is really selective in that it doesn't go after powerful leaders, it only goes after other people. It's one of the peculiarities of the 2018 entry into force, as you say, that you can't prosecute somebody from a non-state party. And there are a lot of other complications to do with jurisdiction over aggression. And I think it's very unlikely that we will see prosecutions for aggression. It's not just that Russia and China and the United States got a free pass. It's most states are not going to ratify the amendment which would allow for prosecution. So also British leaders, French leaders are not going to be prosecuted. So I think one just has to accept that states are not prepared to give an international tribunal jurisdiction over their leaders for aggression. Yes, you can say it's the fault of the ICC, but it's not really. It's the fault of those states who have steadfastly refused to allow the ICC to do this. So if you want to blame people, you can blame the British government, the American government, the French government, but you can't really blame the ICC as such. Now, is it a good idea to have something in parallel? I would say yes. It will allow the story of the aggression to be told. It will allow for the identification for those who have been most involved in planning and executing it. And my hope would be that, again, that might give people who are thinking about planning an illegal use of force pause for thought, because even if it comes 10 years after the invasion or 20 years, it's going to be about them for the rest of their lives, whether or not they actually capture somebody and put them in prison. But the process of preparing the prosecution highlights that there is no right to go to war. It's a crime. And that, I think, focuses people's attention. And again, I think the knock-on effects for those who are a bit more junior or who are related and in the commercial world assisting such an aggression is perhaps where we should be focusing, because those are the people who are going to be, in a way, more vulnerable because they want to travel and they have assets. And it's more likely that those could be frozen and taken away from them. And given a choice, do I assist in this war of aggression or not? I'm hoping that some people will decide not to, when they're having seen that a special tribunal on aggression comes after quite a wide range of people and not just the president or prime minister.
And in recent developments in the war, we have been made more aware of the Russian-funded special forces by the name of Wagner Group. So what is the status? Are they mercenaries, or are they in effect Russian armed forces? What legal framework governs their status, and could Russia have certain responsibilities in relation to these crimes, and how we can hold them accountable?
Yes, well, it's a fast-moving area. So if we go back a while to when Wagner was disconnected from the Russian state more formally, they're often described as mercenaries. The problem with that is that, of course, politically and in the media terms, that they do look like mercenaries, but technically, as a matter of international law, the definition of mercenaries found in additional Protocol 1 to the Geneva Conventions says that you can't be a mercenary if you are a national of a party to the conflict or a resident of territory controlled by a party to the conflict. So members of Wagner who are Russian nationals, or even people of another nationality resident in the Donbass, say, which is controlled by Russia now, can't be a mercenary by definition. So if captured, they would have to be given full prisoner of war status, and they couldn't be prosecuted as mercenaries because they wouldn't fit that definition. And anyway, they would have prisoner of war status. So that's a bit complicated. On the other hand, you might have somebody from Syria working for Wagner, which happens, and they would be a mercenary. and would not get prisoner of war status. Now, the sort of more complicated part is that another way in which you lose your mercenary status, if I can put it like that, is if you're integrated into the armed forces of the state. So to the extent that Wagner are now integrated into the armed forces of Russia, and it seems, according to the media reports, that they will come under the Ministry of Defense and so on, and be under command and control, then even if they are paid and they don't look like the armed forces, they would be the armed forces and they wouldn't be mercenaries, whatever their nationality. So it's super complicated, and you almost have to go case by case and day by day, because on one day they might be integrated and and in the past they weren't. Now that's the situation in Ukraine. It gets much more complicated when you go to Mali or one of the countries in Africa where Wagner are operating, because there's no question of it being an international armed conflict and them having prisoner of war status or losing that if they're mercenaries. And there's an African Convention on Mercenarism and the UN Convention on Mercenarism, which might create criminal responsibility for some of them. But again, you'd have to go situation by situation and almost individual by individual as well, because there are questions of motivation of the individual that are part of the mercenary definition, whether they're doing it just for money or for some other reason. So it gets very complicated. To answer your second question, the extent to which Russia is responsible, if they become members of the armed forces of Russia, then they're automatically responsible for them. If they are not, and they are being directed by the Russian government, then under the law of state responsibility, Russia will take responsibility for what they do during the operation that is directed by Russia. So that's the law on that is found in the Nicaragua against United States judgment at the International Court of Justice, and in the law on state responsibility. And it's again, it can get quite complicated. You have to know which operation we're talking about. But in short, the Russian government would be responsible as a matter of international law for those operations which they have directed, both for the violations of human rights law and for the violations of international humanitarian law. When it comes to accountability of the individuals working for Wagner, there we forget sometimes, I think, that they can all be held accountable for any war crimes or crimes against humanity, or genocide even, if that was appropriate, at the International Criminal Court. The International Criminal Court has jurisdiction over anything that happens in Ukraine, and obviously in a lot of the countries in Africa where Wagner are operating. So we could yet see individuals from Wagner prosecuted at the ICC. It's only aggression that can't be prosecuted at the ICC, but the other crimes can be. And to the extent that their crimes are grave breaches of the Geneva Conventions, going back to my earlier theme, they could be prosecuted anywhere in the world. So Wagner are a bit different. The individuals in Wagner are a bit different from the leadership of Russia, say, in that they do want to and need to travel around the world. And I would say they're vulnerable to being arrested. I mean, those who are wanted for war crimes, to being arrested and prosecuted anywhere, because if they're grave breaches, there'll be crimes of universal jurisdiction. And many states will prosecute crimes committed in internal armed conflict, maybe committed in African countries where Wagner is operating. We have recently quite a few prosecutions in Switzerland related to Liberia, where people are being prosecuted for crimes committed in that non-international armed conflict under Swiss law and international law.
From your point of view, how can justice be served for victims when we can only try these international crimes in the aftermath of the war, when they have already been committed, lives lost, and most victims have already obtained some form of financial redress, especially when we consider the extensive financial resources and many years it will take to see accountability. So, in other words, obviously there has to be a balance when you're prosecuting crimes of this gravity. It takes time, it takes a lot of money, but essentially what does ICL and justice mean in the ICL mean to you?
I think we have a sort of traditional understanding of international criminal law as coming in the transitional justice phase or post bellum phase. And, the image that always comes to mind is those pictures of people being prosecuted in the Nuremberg court or the post-Rwanda prosecutions. But in fact, the Ukraine conflict is reminding us that people can be prosecuted in the middle of an armed conflict. And there have been some prosecutions in Ukraine. And I wouldn't be surprised if we don't see a prosecution at the ICC before this conflict is over. So I don't think we should assume that prosecutions only come at the end of a conflict when you have a winner and the winner gets to prosecute. I think this conflict is a bit special in that we have a developed system of international criminal law up and running, and we have expectations that there will be prosecutions. So there were prosecutions recently in Ukraine regarding Bucha, war crimes allegations. Now, if I've read it correctly, these were crimes held in absentia, so they didn't actually have the defendants. But this may be a new way of dealing with the truth, of allowing witnesses to have their say, as you point out, before things are forgotten and things have moved on. So I think we might be seeing a new type of international criminal law where it's as much about retribution and punishment as about victims airing their grievances and a story for the historical record, and identifying perpetrators who, even if they are not immediately captured, are going to find it increasingly difficult to move around the world. It's difficult now to go through borders with facial recognition and with electronic passport controls. Even when you get on the plane, you're scanned. I think it's going to be a different approach rather than a show trial where you have, people standing up and photos. It might be more about casting the net wider and not knowing exactly when somebody is going to get caught. I mean, I might stress that these war crimes and crimes against humanity that we're talking about are crimes which have no statute of limitations according to international law, that you are not supposed to say, well, after 10 years or 20 years, that it's impossible to prosecute that. So, you might think you've gotten away with it, but you'd also be aware that in 20, 30, 40 years' time, somebody might recognize you as a person, even if you've changed your name, and that your freedom then might be curtailed.
You've written about the limits of human rights protections in times of armed conflict. Has the advent of social media and real-time documentation of these abuses increased accountability, and can those tools be used to further increase the reach of human rights protections in times of conflict, and even in terms of witnesses as these courts and use of evidence?
Yes, in my experience, it is increasing accountability, certainly in the sense of people being held account, even if it's not leading to so many prosecutions. But social media has enabled investigators to know who was where and when. So if they've posted a picture of themselves at a particular site, giving a speech, encouraging people to do this, that, or the other, then that's part of the story. They can't say, I've never gave that speech, or I wasn't at that place on that day, because it can all be pieced back together. And the other real-time element in this is not just the photos and the postings and the videos, but also the satellite imaging, which is a new aspect to human rights investigations. So if you are trying to prove that a village was destroyed on a particular day, and you know that troops from one particular party to the conflict were there at that time, and you can see them moving, and then you can show a before and after satellite image, that builds up a picture in a way that interviews with witnesses can't quite, in terms of the persuasiveness of it. So a lot of the technology, it's not just related to people posting, and I think people will become more wary as they realize that they're implicating themselves. But it's also the technology of having an eye in the sky, to use that expression, which will be able to show who moved where and what the results were. And I think that is quite important for accountability.
On a final note, we wanted to know what you think the future of Ukraine would look like in an ideal world, or, how do you think this would progress? Do you think we could see an end to it anytime in the near future, or what would you think?
Well, I would hope for an end to it as soon as possible. Um, it's not really for me to design the future of Ukraine, but I understand your question. I suppose I would want it to be under the rule of law. I would want it to be unoccupied, and I would want it to be peaceful.
That was really, really valuable. And thank you so much for giving us your insights today and for giving us your time today.
No, thank you. They were great questions. You managed to cover a lot of tricky issues.